Hello, my name is Crystal Dahl and I'm the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, U.S. Immigration, a One-Year Look Back. For those of you new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in over 240 markets around the world since 1990. Meritas Capability webinars are regularly presented by Meritas members. Before we get started, I want to go over a few housekeeping items. Meritas now offers the ability to listen to our webinars through your computer speakers, but if any time you have any difficulty hearing the presentation, you may also call into the associated telephone line instead. All the phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. Joel plans to answer questions at the end of the presentation. Lastly, in the next few days, I will distribute a copy of this presentation, a recording of the webinar, as well as Joel's contact details. Our presenter today, Joel Pfeffer, is a partner of our Pittsburgh, Pennsylvania Meritas member firm, Meyer, Unkovic & Scott. He is a chair of the Corporate and Business Law Group, a member of the International and Immigration Law Group, and is a member of the firm's Management Committee. Mr. Pfeffer works primarily in the areas of immigration, nationality, and corporate law. Welcome, Joel, and with that, are you ready to get started?
I am, Crystal. Thank you very much.
You're welcome.
Okay. We are going to talk today about how President Trump and his administration have changed the face of U.S. immigration, or I think have started to change the face of U.S. immigration. A number of important changes have occurred over the last year, and we'll take a look at those. And then we will talk about initiatives from the administration that affect U.S. business and some announced immigration policy priorities from the administration. When President Trump was inaugurated shortly thereafter, he promulgated some presidential executive orders and presidential proclamations, and on October 8th, he announced his immigration policy priorities. Now, with respect to the presidential proclamations and executive orders, each of the government agencies that affects immigration and travel to the United States has announced new procedures that affect U.S. businesses, most of them having their origin in one of 3 executive orders and proclamations. Now, there are 3 government departments that control immigration: the U.S. Department of Labor, the Department of Homeland Security through the U.S. Citizenship and Immigration Services, and through ICE, the Immigration and Customs Enforcement, and the third being the U.S. Department of State through its consular posts abroad. There has not been much activity from the U.S. Department of Labor in terms of announcements. There has been much activity for the part of the Department of Homeland Security, and there have been some obvious changes in the way that the Department of State conducts its business. All these changes appear to have their source. They've not announced their source in this, but they appear to have their source in the proclamation that puts in effect the travel ban, the executive order on Buy American, Hire American, and a similar executive order on border security. So let's review what's happened over the last year with the travel ban. The initial travel ban was shortly after. I skipped a slide here. No. Each of the travel bans were announced shortly after the president was inaugurated, and it prohibited admission from several countries, what were called countries of concern: Libya, Syria, Iraq, Iran, Sudan, Yemen, and Somalia. The list of countries that were initially targeted for the ban were several countries that the Obama administration had previously targeted as countries of concern in connection with people who traveled to those countries would receive special scrutiny when seeking to enter the United States after travel to those countries. The Trump administration seized on that list and initiated what was called a travel ban. The travel ban, unfortunately, was not totally comprehensive. There were many things that were left out of it. There was, for example, nothing that was said about dual nationals, people who had other citizenships and traveling on those passports. Nothing was said about people who had valid visas to enter the United States. And I don't believe anything was said about people who were in the United States who were seeking other benefits, such as adjustment of status to permanent resident. So there were no clear guidelines, and significant hardships were visited on travelers. Following that, there were court injunctions, restraining orders. Eventually the matter came to the Supreme Court. Eventually the matter was called moot by the Supreme Court. And now we had a March 6th travel ban that was exempted, that addressed these issues, exempted permanent residents of the United States from the travel ban. It exempted dual nationals traveling on the passport of a non-restricted country. It indicated that it had no effect on aliens in the United States or in possession of a valid visa. So all of those people could enter the United States. The March 6th travel ban removed Iraq from the list of banned countries. And of course, needless to say, court injunctions put a hold on much of this travel ban. The last of the proclamations was issued on September 24th, and it imposed travel restrictions on nationals of Chad, Iran, Libya, North Korea, Syria, Venezuela, Yemen, and Somalia. Now, what happened in between was that the earlier proclamations instructed the Department of Homeland Security, the Department of Justice, and Department of State to research the information available from various countries as to who is a suspected foreign national who might have terrorist ties. And there was a study released, and the result of that study was these are the countries that are countries of concern. Now, of course, the matter was taken to court. The courts have limited interpretation except for 6 countries, Chad, Iran, Libya, Somalia, Syria, and Yemen, with those citizens without a bona fide relationship to the United States. This is a concept that has appeared in these travel proclamations. Somebody with a bona fide relationship to the United States can enter the United States. North Korea is still banned from this, under the ban, and Venezuelan government officials are still banned. But pretty much everybody else are not restricted, and I believe that, and the 6 countries listed, you can show that you have a bona fide relationship with somebody in the United States and obtain a visa. Now, going back to the January 27th, the first of these bans, it defines as its purpose ensuring that those admitted to the United States do not bear hostile attitudes toward the United States. It calls for enhanced vetting procedures and rigorous enforcement of grounds of inadmissibility. The Department of Homeland Security, as we'll see soon, has embraced these ideas of enhanced vetting procedures and rigorous enforcement of grounds of inadmissibility. Grounds of inadmissibility are statutory bars to enter the United States. Often they're either bars to entering temporarily or bars to entering permanently, and they have typically been screened on the basis of questionnaires. And as we will see, this concept of enhanced vetting and rigorous enforcement has turned into face-to-face interviews for virtually everybody that wants to enter the United States. Okay, so let's turn to the initiatives that affect U.S. businesses and how they affect U.S. businesses. The U.S. Citizenship and Immigration Services is a bureau of the Department of Homeland Security, and historically it has interviewed, it has mandated interviews for permanent residents who seek to come on the basis of a marriage. When you have a marriage, they want to see you. They want to see whether you have the couple has financial ties together. They ask questions about how the couple has met, about the dating, how they've dated, and questions that are designed to determine whether to determine the bona fides of the marriage. Historically, or at least for the last 20 or 25 years, the government has interviewed very few people who have applied on the basis of employment. In order to apply on the basis of employment, you have to show that you are either outstanding in what you do, and the government can waive any job offer, say we don't need to see that you have a job offer, but we know you can make a living in the United States, or you can have a job offer in one or two various categories that do not require testing of the labor market. But most employment-based immigrants enter the United States on the basis of a test of the labor market sanctioned by or supervised by the U.S. Department of Labor. Once the Department of Labor approves a case, or what we call certifies a case, the case moves on. You move the case on to the Department of Homeland Security through two other processing procedures that ultimately result in the issuance of a green card. Again, historically, those green cards were issued without a face-to-face interview by the Department of Homeland Security asking questions to the applicant or the person who was what we call the beneficiary of the employer's petition. The Trump administration changed all of that and has announced that the USCIS will interview all employment-based green card applicants. The interviews are designed to confirm the employee's qualifications for the position and prior experience. Now, it is not clear how the plan will be phased in. Well, what is clear is that they're going to interview everybody. What probably will vary from office to office, these interviews are conducted at the local office, and what will vary from office to office is how deeply, or perhaps from officer to officer, how deeply the interview will probe into the history of the foreign national, how the labor certification was secured, and whether or not the foreign national and its employer meet all of the requirements for the position. That would be a very, very deep analysis of the process, which probably will take place in a few offices by a few officers, but for the most part, or at least what we're seeing at this point, for the most part, the interview just addresses whether the foreign national is subject to any reason why he or she should not be allowed to undertake permanent resident status in the United States. Do they have a criminal record? Have they ever had an immigration problem? Do they have some, or they have anything in their background that would be a bar to enter the United States? And are they in fact filling the position for which the green card is being issued? And often there is request for confirmation of that by submission of pay stubs and letters from employers. Those interviews will be standard for those interviews, but you can expect that there will be some local offices and some offices that will dig more deeply into this and will, to the extent they can, address whether in fact the test of the labor market was conducted properly, whether the employer has in fact the ability to pay the salary, and other issues that you have to overcome before you get to the end of this road. I should warn you that many of the officers who might be asking these questions do not have training or experience in these issues, and attorneys are going to have to be vigilant about those kinds of questions where it's obvious that the officer is not schooled or not trained in the issues that they are addressing. That is not an uncommon problem. and it probably will surface in these rounds of interviews. Now, one other problem with the interviews is that the government does not have the capacity to conduct that many more interviews, but they are under a mandate to do so. Now, what's going to happen here is that the local offices are going to be pressured into making these interviews, these employment-based interviews, on a timely basis. The reason for that is that there are a limited number of employment-based green cards available every year. There are 140,000 employment-based green cards available every year, and it is a no-no to allow them to go unused. So if the government were to delay these interviews, the result could be that 140,000 will not be issued in the government's fiscal year, which ends on September 30th. That can't happen, and the Department of Homeland Security knows that. I mean, it can happen, but it's not. It wouldn't be. It would create a response from the immigrant community that the Department of Homeland Security doesn't want to see. So they are instructed the local offices, and they've instructed the system that sets up these interviews to conduct them on a regular and timely basis. What that's going to mean is that to the extent the local office cannot handle other kinds of interviews, like marriage interviews, those will get pushed back. For example, right now in New York, interviews for marriage cases are running over a year from the time you file to the time you interview. Other offices are less. 6 months is about the average, or the 6 months is the projected timeline. But it can go anywhere from 6 to 12 months, and in some places like New York or Newark, it's running more than 12 months. And I expect that timeline to continue to get longer. Another thing about what's happened here is that this extreme vetting pronouncement from the administration means that there's going to be certain marriage cases that were previously not interviewed. For example, after 2 years, a couple must come back to the government and file another petition that asks to remove the 2-year condition. In most cases, there's a 2-year condition on that green card, and you have to come back after 2 years and show you're still married, or if you're not married, that the marriage was viable at the beginning. Those cases have been interviewed only on a random or suspicion-based basis. There's going to be the Department of Homeland Security is looking at interviewing every one of those cases, so that's also going to be a drain on the system. Okay, now moving to the Department of State. The Department of State conducts interviews at its consular posts, which are U.S. embassies and consular offices abroad. They have been instructed to identify applicants and population groups for additional screening. There is something in the world of consular processing called administrative processing. That means that when they have questions about your case, they just put it on hold for at least 30 days or 30 to 60 days. Administrative processing used to mean, and probably in most cases still means, applications by individuals who have some kind of sensitive technical knowledge that the government is concerned would be they're in a field that if they gain certain knowledge in the United States, they would take it back to their home country. So there's been an administrative processing clearance on these people, and some of them have been stuck, particularly in India and China, for periods of 30 to 60 days. But we're seeing that the term administrative processing is expanding to other people. I can give you an example that I have a situation in Peru right now where a nun is being held she's not being issued her visa under the administrative processing cloud, and there's really nothing I can do about it at the moment. I have written to the consulate explaining how the sister is entitled to this visa, and that I cited to them, if you will, chapter and verse as to where it says that she meets the qualifications, but I've gotten no response. and after a certain period of time, in these cases, you can go to the State Department and ask them to look at this and perhaps intervene. But now we're seeing administrative processing applied as a term in many more broadly. Another issue is students and employees with approved employment status may be subject to an exception or granted a waiver. Those are travel ban countries. You can get a waiver if you have some reason to come to the United States. You've already been in the United States. You're a student. But I think we can expect that as this travel ban winds its way through the court and perhaps the Supreme Court weighs in on it, that we're going to find that students are going to be discouraged from seeking to be educated in the United States, and that education in the United States is a big business, and there are many, many foreign students here, and you need to be on the lookout for clients who may be universities or schools that are going to be asking questions about citizens of certain countries, or even anybody who is subject to these extensive vetting procedures being denied visas abroad. I should say, as a matter of background, after 9/11, the government shored up its ability to track who is in school and who is not. Every time someone either applies for a visa, the first step is the school issuing an acceptance that's tracked on a web-based system that immigration officers and consular officers can see, called SEVIS. When they enter the United States, there's an entry in SEVIS. Every time there's a new semester, the school has to enter the student in SEVIS. So this has created a mechanism by which the Department of Homeland Security can monitor who is actually attending school and who is not. And to its credit, the Department of Homeland Security has effectively used this as a tool to monitor the activities of students in the United States. Okay. All right. Now, another one of the executive orders was dated April 18th, and it addressed Buy American, Hire American. It directs federal agencies to review all of the non-immigrant visa programs. There are several non-immigrant visa programs. These are visas for temporary entrance to the United States to work. The most popular one is H1B. We will discuss in a moment what's happened to that program. Another one is intra-company transferees, called the L program. We'll discuss that in a moment. Another one is the treaty trader or treaty investor, E-visas, those countries that with which the United States, some 80 countries with which the United States has treaties, and the citizens of those countries can enter the United States to manage their investments or conduct trade between the two countries. Those are examples. Religious workers is another example. Students is another example. These are examples of non-immigrant programs, and the government has been instructed to review everything. They've also been instructed to propose reforms to the H1B program to prevent displacement of American workers. And last year, in what we call the H1B season, we saw a number of changes to the program. They weren't proposed, they were just implemented. And encourage the use of H1B program to accommodate the highest paid workers, most skilled workers. And the USCIS has reported that it is working on a combination of rulemaking, which would be required to change a regulation, policy memoranda, which is typically how a regulation is implemented, operational changes, and of course, Congress would have to change anything that is statutory. Now, getting to the H-1B program, this is the core, the most popular of the temporary employment programs. It requires that the individual coming to the United States be filling a professional position, that person have professional skills. So definitionally, that means that the position, in order to fill that position, the individual would have, the worker, whoever filled it, would have to have a college degree as an entry-level requirement. The second prong, the professional employee, that the person in fact has a college degree or its equivalent in experience. and that what's unsaid on the slide is that there has to be a relationship between the position and the required degree and the degree the individual has. Finally, the program requires that the individual be paid a prevailing wage. Now, how do you know what the prevailing wage is? There's two ways to find out. One is to file a prevailing wage determination request with the U.S. Department of Labor. That takes about 3 months for an answer, and in an H1B case, it's rare. I believe it's rarely done. Now, it is required in a green card case, and it's got to be done, but I think it's rarely done in an H1B case. Now, the other way is to log on to the Department of Labor statistics, the same ones that that determinations are made when you ask them to do it. You log on to their statistics, and you see there's, I don't know how many, probably 100 or so job classifications that they will give you statistics for. They're keyed into various locations. The Labor Department has metropolitan statistical areas that it uses, and the prevailing wage statistics are keyed into those areas. So you look up for where the person's going to work, and you'll see there are 4 levels. There's entry level, level 2, level 3, level 4. Now, there was a time when there were only 2 levels, and the immigrant bar and the immigrant community complained that 2 levels is not sufficient because you got to, once you get beyond entry level, there have to be different grades of pay. Well, and then so they created 4 levels. Now, be careful what you pray for. What's happening now, what we're seeing now in the last H1B season, and I'll tell you what season means in a minute. In the last H1B season, we saw the U.S. Citizenship and Immigration Services challenging anything that was earmarked at level 1. So if you're paying a market research analyst, for example, $25,000 or $30,000 based on level 1 Labor Department statistics, they would say, wait a minute, you're only paying level 1. That's not a professional position. And there were serious challenges and many denials on that basis. I don't think there's any basis for saying that, but that's what they're doing. Now, so that's something new that is really an implementation of the Trump order of Buy American, Hire American, and it really, frankly, I don't believe it has any basis in statute or regulation. Somebody will eventually take them to court, and a court will probably stop this practice of challenging entry-level professional employment by saying that you cannot use a level 1 wage, or if you do, you have to show, like, is it really a profession? And you have to have, there's an added burden of evidence. Now, I spoke a few times already about the H1B season. Let me just say this. There are a limited number of H1Bs available. There are basically 85,000, of which 20,000 are reserved for graduates of with U.S. master's degrees, and there are over 200,000 applicants every year. The government will allow you to apply on the first week in April. They'll take applications. Those applications, if approved, become effective on the first day of the government's fiscal year, which is October 1st. And they conduct the lottery, and by the end of April or early May, they announce who are the 85,000 lucky winners whose cases will be reviewed. During the spring and summer, they will review the cases, and people will hear back. Are there challenges to your petition? Is the government saying that perhaps it's not professional, or are they challenging the ability to pay the salary? Are they challenging the relationship between the professional position and the employee's credentials? In the end, you have to take a look at, or it's actually in the beginning, before you submit it, you got to take a look at, is this company an appropriate employer for this position? So you can't have a convenience store applying for an in-house accountant, for example. Now, they won't challenge you by saying, why do you need an accountant? But they'll find their ways to challenge those kinds of cases. So there are admittedly, there are cases that they review that are challengeable, but there are many cases that are legitimate, and it's the attorney's job to package it in a way that substantiates the argument that or presents enough evidence to overcome the thinking on the part of the Department of Homeland Security that perhaps this is not a viable H1B case. Okay, that's all I have to say about H1Bs. If anybody has any questions, you can post them on the chat about H1Bs. Let's move to the L1 program. The L1 program is available to employees of multinational companies that for an employee who has worked abroad for 1 year or more during the prior 3 years in a managerial, executive, or specialized knowledge capacity. That means that now the advantage of this is there's no prevailing wage issue, there's no lottery. All you have to do is show that you meet the requirements. Again, the requirements are that there's the employer is a multinational company. It has it does business in the United States, or you can propose a new branch office in the United States, which will get you a 1-year visa, or you can, or the company can be an existing business conducting business in the United States with a branch or parent or affiliate or subsidiary abroad, maintaining that subsidiary abroad during the entire course that this manager is going to be in the United States. And you have to establish that the person is either executive, which means at the highest level of management, managerial, which is a mid-level of management, or not management at all, specialized knowledge. Now, we'll define specialized knowledge in a moment. Managerial and executive individuals can come to the United States for a maximum of 7 years. Specialized knowledge can come for 5 years. If the employee is executive or managerial, there is the opportunity to get them a green card, permanent resident status, without testing the U.S. labor market. Now, before the Trump administration came in, the U.S. Citizenship and Immigration Services issued a policy memorandum on August 17, 2015, defining specialized knowledge. So it used to be that you could bring somebody to the United States if they understood your processes and procedures. If you had patented, if they knew how your equipment ran, these are engineers, for example, who design your equipment abroad, you can bring them to the United States, and there were typically no questions asked in a case like that. What the government decided to say was that, no, that's not enough. You have to be really unique, either in the company or the general marketplace. So you have to show, in essence, that there's a shortage of people who have this skill. Now, again, this goes beyond the statute, or at least many believe it goes beyond the statute, and excludes anyone who has commonly held knowledge. It excludes anyone whose knowledge lacks, or the application of the knowledge is not complex, or can be easily taught from one person to another. This has complicated the adjudication of specialized knowledge workers coming to the United States to fill these positions. So this is not something new that the Trump administration has brought on us, but this was published in 2015. But needless to say, the Trump administration and the current policy of the U.S. Citizenship and Immigration Services has not let up the gas on this one, and it is still quite difficult to get a specialized knowledge worker into the United States. I might add that for sizable companies, there is another process called what's called blanket, which means that the company can be approved to apply directly at the consular post abroad. And at the moment, and I suspect this will eventually change, but at the moment, most consular posts are much more liberal about who qualifies for specialized knowledge. I give them credit for that. They probably understand the need for the need of a multinational company to transfer talent to the United States and in order to remain competitive, and they are less. They are much more liberal about who they issue specialized knowledge visas to. The USCIS policy memorandum, I guess you could say they've not read them. They didn't get the memo yet. But eventually, the strict interpretation of specialized knowledge will make its way to the consular posts abroad. But in the meantime, that is available for more streamlined processing by going directly to the consular post, which can only follow an approval by the U.S. Citizenship and Immigration Services that the company meets certain requirements in terms of income or how many cases it's processed in order to have that luxury. Okay, another initiative that affects U.S. business is something called EVerify. On August 8th, the USCIS announced that it encourages business to use EVerify verification process. Going back to the Bush administration was very, very committed to EVerify. It tried without success to get Congress to impose EVerify on every employer, and where it could, it imposed it on employers such as those with federal contracts and other situations where it encouraged employers to use EVerify. Okay, what is EVerify? EVerify is, at the moment, a voluntary process for employers to verify the employment eligibility for new employees, and it ties into a database that is Social Security database, an immigration database, and when you have a new employee, you enter the information about that employee, and the system comes back telling you whether the person is authorized to work in the United States. I list here the places where the Bush administration sought to encourage employers to use this, but government programs and additional time for a student to stay in the United States after graduation. But at the moment, it is voluntary. Whether or not the current debate in the Senate will address EVerify remains to be seen. Whether it be part of immigration reform, if there is any, remains to be seen. And frankly, this administration hasn't talked much about it other than this announcement. The Bush administration was really serious about it but was unable to put it in place. EVerify works with the employer signs a memorandum of understanding with that it will inquire about any newly hired employees at all or specific work sites with this database. The system queries the database of the Department of Homeland Security and the Social Security Administration, and prospective employees who are get a hit. In other words, the system comes back and says, we cannot confirm this individual's authorization to work in the United States. It puts the burden on the employee to resolve that and come back to the employer and say, yes, I've resolved it, I can begin working. So that's an initiative that the Obama administration is supporting, and I think that eventually it will become mandatory for everybody to do it. I am not hearing from people that do use it that they're finding it burdensome, and I think that eventually that will become part of the law. But at the moment, it's not. It's not. The wall seems to be a higher priority. Okay. The government, the Bush administration, the Trump administration has asked for an additional 10,000 immigration officers who will heighten security of U.S. businesses, particularly those in target industries. Now, what that's going to mean is that there's going to be more I-9 compliance audits. As everybody knows, I-9 is a form that you need to complete when you hire a new worker, and accordingly, you can expect that there's going to be a dramatic increase in the number of inspections for production of I-9 forms and other business records, and perhaps even fines for failure to comply, and perhaps even criminal investigations. And if your client is in a target industry, such as hospitality, farming, food production, clients need to be aware that this is going to come down the pike. Some thoughts about how to deal with this. Number one, conduct an internal audit of your I-9 documents. Train people. The employers should train people to prepare these properly. It shouldn't be something that's just delegated. Go figure it out. The employers, the HR managers should be trained, or at least have people underneath them who report to them who are trained to fill out these I-9 forms, to know which documents to review, how to correct the report if there's a deficiency, and that they need to terminate anybody that cannot produce the appropriate documents. Employers should consider whether they want to enroll in EVerify. That would sort of take the pressure off any kind of site enforcement. If you can say, well, we belong, we use EVerify. Now, some employers just can't do that. I mean, when you say to them, why don't you use EVerify, they say, I have to keep my business running, and either they are, there are many documents out there that look legitimate and are not, and sometimes employers don't want to know about that. There are also people out there who have various spellings of their names, and they can't, the EVerify will come back with a hit when the name doesn't match properly. If your client has had a previous inspection, or if a business has had a previous inspection, then know that this is not the end. They're going to come back. They're looking at the particular industries, again, food service, agriculture, hospitality, manufacturing, apparel manufacturing, among others. More white-collar employers don't usually get hit with this, banking, healthcare, insurance, but it happens. I think every employer should have a protocol. Somebody who is in charge, if the government shows up and says, I want to see your I-9 documents. Typically, the government will give you 3 business days to gather those documents, and typically you can ask for an extension. They may ask simply for the I-9s, or they may also want to see payroll records, tax filings, employment applications, personnel files. And it's important to tell businesses that the I-9 records should not be kept in the personnel files. You'll never find them. I mean, you should keep I-9 records separately. There should be 3 kinds of I-9 records. Employees who have, or current employees, employees who have left the company, and employees cases those that did not pass the verification test. In other words, those that you've rejected. So current employees, terminated or departed employees, and those cases you've rejected should be kept in separate piles, so to speak. But the I-9 forms should not be kept in the records of the employee. They should be kept separately. There should be somebody who's instructed, how to deal with the government officials when they show up. Take them to a conference room, and the receptionist take them to the conference room and have somebody, the proper person who understands the rules and regulations, deal with them. Okay. Border security. The Trump administration has announced certain immigration policies, policy priorities. One of them is border security. They want to, Department of Homeland Security has been authorized to raise and collect fees, visa services, border crossings to fund border security, which is why when there's a government shutdown, this continues to operate, because they run on fees. Now, one of the things that the administration has said it's going to do is increase northern border security. That means entries from Canada, which sort of been under the radar for a long time, are going to be given greater scrutiny. What's happened in that area since the last year is that certain processes and procedures, for example, what I described earlier about the L1 intracompany transferees who have an easier day at the consulate, they have historically had an easier day at the northern border where Canadians can make application for entry as multinational transfers under the L program. But now the officers who work the northern border for the Customs and Border Administration have been trained by the USCIS to enforce the memorandum that I discussed earlier and to increase the level of scrutiny and to abandon the liberal approach that they previously were taking and to strictly enforce for example, the memorandum on specialized knowledge, so that it's become an issue of whether or not it's better to send a Canadian to the border to be grilled by a Customs and Border Protection officer, or to do this in the mail through the U.S. Citizenship and Immigration Services, because it is becoming a difficult process to get an entry from Canada in this specialized knowledge category where a multinational business can send somebody to the United States who has special skills. So that's just an example of how the border, they're tightening the northern border, and over the years, and this continues, entry to the United States requires them to view in a system that has in it prior history, particularly criminal history, and they are just putting more and more information into that, and events that occurred many, many years ago are now showing up in that system and preventing people from entering the United States. And even cases where a criminal matter has been expunged will show up there. This process does not recognize expungement. Expungement doesn't help you here. So the officers can see that something happened, they just don't know what it is, and they'll grill the applicant as to what it is that the expungement is all about. This might catch some people off guard, because the layperson might think that expungement means it's like it never happened. Well, the Department of Homeland Security doesn't view it that way. So these are things we're seeing on the northern border that either began earlier before the Trump administration and now become much more common. Interior enforcement, that's the rest of the country. Again, 10,000 more ICE officers, 300 federal prosecutors. Again, protect U.S. workers by requiring EVerify, strengthening laws to stop employment discrimination, and improving visa security at the consular posts. Let's see. Okay. Before I get to the merit, the Trump administration has suggested that we move away from our current system of family-based immigration running in tandem with employment-based, and we establish a points-based system for green cards to protect U.S. workers. The White House released on October 8th several documents outlining its policy priorities. They were divided into three categories: border security, interior enforcement, and merit-based immigration. There have been a number of proposals in Congress, including appropriations bills, that would spend a lot more money on immigration detention and immigration investigation and enforcement agents. The president asked for money for his border wall. The merit-based reform proposals are drastically cut immigration levels. Right now, again, we have 140,000 employment-based green cards. There have been proposals in Congress to cut that back. There have been proposals in Congress to end the ability of a U.S. citizen to bring a sibling to the United States, which I would think is going to eventually pass. Proposals in Congress to criminalize overstays. Someone stays over, it's not a crime, it's a civil matter today. Proposals to criminalize undocumented immigrants and to somehow that way encourage mass deportations. And of course, there's always the discussion about the heated discussion about DACA, which is the Deferred Action for Childhood Arrivals, which was initiated by the Obama administration to provide a way for them to obtain employment authorization. When it comes to visa overstays, this is important to the business community. Visa overstays account for roughly 40% of illegal immigration, but an overstay is an overstay. You overstay one day. The rule is, this is I believe a statute, that your visa is no longer valid. You can't use it to come back. It is not criminalized, but they want to talk about that. They want to talk about any overstay would bar you from returning for any period of time, so the consulate cannot issue you a new visa, and they want to increase the information that's available. They've always had a problem. Prior administrations have had a problem developing an exit procedure where the government is aware of who leaves and when. The Trump administration has proposed that their Department of Homeland Security investigate how that could be implemented. If you've ever traveled abroad, there are many countries that do that. You've got to show your passport when you leave. At the moment, our government monitors that by flight manifests, but those can be inaccurate. You can travel outside the country on a land border, and it's really important for anybody who comes and goes to the United States to maintain accurate records and proof of when they've come and when they've left, so that there's no suspicion or challenge that on the next entry that they overstayed. Okay, let's review what we've talked about here and the practical considerations. Interview protocol at U.S. consulates abroad is increasing. A consular officer probably has 3 minutes to conduct an interview, and there's little they can accomplish in 3 minutes, but they're under pressure not to admit anybody who has any issues, and that's causing an increase in denials. Administrative processing, putting cases on hold while they review the individual or the job or the relationship with the employer. Oftentimes they will, when there's an intracompany transferee, particularly in China, they're going to look and see, okay, let's send an investigator out to see if this company really exists here in China. Those kinds of things are on the rise. Consulate adjudications of approved petitions. In many cases, the Department of Homeland Security says whether this case is a valid case. The employee takes an approval notice to the consulate and seeks to get a visa, and consular officers are now looking at these and saying, oh, is this truly true? Did the Department of Homeland Security make a mistake here? And seeing an increase in the number of cases being returned for re-adjudication or revocation. We talked about Canadian border adjudications. Nothing. You can't send anybody to the Canadian border knowing that, or with the same kind of confidence you once had that there'll be no problem. If they have any kind of background history or they're coming in on any kind of sensitive kind of adjudication, they need to be well prepared. U.S. Citizenship and Immigration Services adjudications. Again, they're looking at everything much more closely. They're applying, in often cases, made-up rules about what qualifies, and if the rule is not made up, it's statutory, regulatory, or policy. They're applying it strictly. Interior enforcement and I-9 audits, we can look forward to seeing an increase in those, and legislative changes in the making. That's something that's going on as we speak. There is discussion in Congress about these issues, and the latest is things that are going to be considered are DACA, of course, the wall, EVerify, quotas, reducing the number of categories that are available. the diversity lottery, a lottery which authorizes admission of 50,000 people on a lottery basis from certain countries that have not sent us many people over the years. I think that's one of the proposals. The Trump administration has proposed changing that, so no, getting rid of that, and all kinds of things. When there's legislative debate, anything can happen, good things and bad things. So stay tuned for that. I don't have anything more to say. If there are questions, I'm happy to take them on the chat. Here's a question. Do you see the Trump administration reducing the number of H-1B visas available to make it more difficult for companies to bring in foreign talent because of the lottery will be much more difficult to, the chances of winning one of those 85,000, if there are only 50,000, the chances are slim. The answer is anything's possible when Congress debates. It used to be there were over 100,000 of these available, and there used to be a time when there was available all year. But do I think they're going to reduce the number? I really don't. I think that's not on the radar. I think that the government will continue to try to enforce or to discourage H-1Bs by administrative action. Okay, my time is almost up. Again, if there's anybody have any questions, feel free to chat. I'm not seeing any questions. Okay, Crystal, you want to bring this to a close?
Yep. Yeah, thank you, Joel. That was fantastic as always. Before we sign off, I just wanted to remind each of you that in the next few days I will distribute a copy of this presentation, a recording of the webinar, as well as Joel's contact details. Please don't hesitate to reach out to him directly if you have any further questions or if something comes up. With that, thank you again for taking the time to join us, and I hope everyone has a great day. Bye.
Bye-bye.